All right. So in this video, I'm going to tell you who can own a medical spa in Minnesota. It's actually not that clear. Let's get to it. Minnesota, not the most clear rules in terms of who can own a medical spa. I'll tell you right off the bat, there is no medical spa license. Everything is going to derive from the actual healthcare license, professional's license, and then we work our way down. So in Minnesota, we have what's called the Professional Firms Rules or the Professional Firms Act. And through that, it is inferred that only licensed professionals who are authorized to furnish at least one category of the professional firm's relevant professional services may own a health service clinic or medical spa. What the heck does that mean? Okay, so a conservative reading of that law is going to say that only medical doctors, registered nurses, those who fall into the professional firm's professions can actually own clinics. Questions I get all the time are, well, what if a medical doctor owns 50%? What about the other 50%? Can that be a layperson like me? Or what about if we have a registered nurse, a dentist, a therapist, and then a medical doctor, and we want a multidisciplinary situation? Minnesota law is somewhat gray on this, and reasonable minds would differ. This is because we have what's called the corporate practice of medicine doctrine, which is this belief that those people who are not licensed medical professionals, if they own a medical clinic, that they're going to influence the judgment of the medical professional. They're going to somehow, influence the procedures, and it'll all be about business and not about independent medical judgment. So we have that floating corporate medicine or corporate practice of medicine doctrine. We don't have a corporate practice of medicine doctrine law. This is actually through two main cases as of today, which would be back in the 50s and the early 2000s. And they aren't directly on point. They don't say, well, actually for a medical clinic, here's exactly what it can be. We're going to outline it, because this is what happens when you have sloppy legislative drafting and you don't really have clear rules, and then it gets litigated. It goes up to the courts, and the courts, when they're not doing the job of the legislature, are just trying to interpret and, find really just resolve the case at hand, but then give a little bit of guidance. So I advise a lot in this area, and there's a lot of gray area. And I think what we're trying to do is, if we are going to push the bounds, we want to be in a defensible legal position. So one thing that I do by default is I advise every medical clinic, any business that is providing medical services, therapy, nursing, anything within the professional firms rules, psychology, podiatrists, chiropractors, mental health counselors, there's quite a few others. Any of those in Minnesota, conservatively, we need to register as a professional firm. Period. Which means you check a nice little box when you're doing this online. And then from there, filing your entity online. And then after that, you have to do the second step of actually sending the professional firm's first report to your respective board. For me, it was the lawyer's board. So when I filed Holt Law LLC, which is actually a professional firm, you don't need to put the P, I'm just Holt Law LLC, but I am a professional firm. And I checked the box saying, yep, law, I'm licensed practice law. And then afterward, I sent a separate election to the lawyer's board with a check to secure that as the filing. So outside of this, it's interesting because other states like California have more of a threshold rule. So at least for a medical spa, medical anything, at least 50% owned by a physician. Minnesota does not technically have that rule. We are in this gray area, but in general, the conservative legal advice is going to be only medical professionals can own a clinic. Now, there are some ways to get around this. Let me talk about number one. You're a nonprofit. Yay, okay, you're exempt because you don't really technically have ownership. It's like board of directors, so that works. Another exception would be, and what I set up very often, and I want to clarify this is not ownership, but what's called a management services organization, or an MSO. This is a separate company that has a agreement with the medical clinic called a management services agreement. And it basically puts the legal tentacles and death grip on the medical clinic and does just about everything that ownership does without actually being an owner. The only thing it really can't do is actually dictate how the professional services, the medical services, are actually done. This is one of the most impressive and useful ways to get involved in medical services, franchising, chiropractic, medical spas, really any sort of advanced specialty clinic. But just do all the business stuff and then have the money flow up to the medical clinic and then over to the management services organization, and generally make a lot of money on doing the, legal marketing, phone calls, the business stuff, all of that. And just the medical doctor or medical doctors just come in and kind of do their procedures, get out, take a nice reasonable salary. So that is a cheat code. Now, technically, what's interesting is for the lawful practice of medicine, you can be charged in Minnesota for a maximum fine of $3,000 or a gross misdemeanor, which, to be quite honest, doesn't seem like that bad. I thought it would be, like felony, something like that. Now you have nearly unlimited exposure to those that you gave advice to and them coming after you civilly, but I'm talking about working with the states. One other thing that I want to throw in here is that you can also protect your legal rights by, and I do this all the time, when I've been in gray areas, one thing I love to do with both the medical board and the nursing board is to explain my analysis of the law. And if you just, Google, who can own a medical practice in Minnesota, my blog should pop up to the top, and AI is crawling it, and it has basically become the answer if you put it into AI and Google search as well. The thing that I do, the trick that I do, is I actually show the entire legal analysis, which is very muddled and gray, and I send that along with a professional firm's registration to the respective medical board and nursing board, which is supposed to outline what the ownership and governance authority is of the respective entity. And if we have something, let's just say, for example, we have a registered nurse in Minnesota that owns the medical spa 100% and then uses a medical director properly, legally, all good. But, still kind of a gray area in the corporate practice of medicine doctrine, because the medical doctor, MD, doesn't actually own the medical spa in that scenario. What I do is I send a nice letter outlining the actual legal authority for what's going on in Minnesota. And I say, listen, if you don't think this is correct, don't cash our $100, message us back and we will set this up a different way. I've done probably somewhere in the neighborhood of 50 of those over the last 5 years. And those checks always get cashed. And I've even had the boards call the client on occasion and say, yep, you're good. Now, disclaimer, this is not legal advice. Don't rely on this for your individual situation. Watching, a random video, this isn't enough to create an attorney-client relationship. But with all that said, I would say it's useful to have written protections like the one I was just talking about, the letter to the board when you actually did the filing, because enforcement in this area could change quite rapidly. If you get an attorney general that is just feeling a little bit more like they want to push the envelope and the interpretation of the rules, and really the lack of the court's interpretation of the corporate practice of medicine doctrine, then things could change rapidly. I think it's nice, and I never use this as a legal defense, but a lot of other businesses are using a more liberal reading of the professional firms rule and the corporate practice of medicine doctrine, which would be to your advantage if you're, going to enter and do it like all of that. But that's not a defense. I would say that a lot of businesses would have to change their legal structure in Minnesota if we had a more aggressive enforcement. Okay, I'll leave it at that. That's who can own a medical spa in Minnesota. Generally, only medical professionals, but the law is gray. See my blog for outlining all of that and the rules and the cases and the law and trying to put it into plain English. And also the subnote is, even if you can't own it, the safest non-ownership, but almost kind of looks like ownership, I'll call it even a legal loophole, is the MSO, Management Services Organization, the separate entity that just contracts with the medical entity and still allows you to profit through doing a lot of the business services. If you found this video helpful, subscribe, follow, all that good stuff, and hope to see you on the next one. Thanks.